All rise. Hear ye, hear ye, hear ye. The Supreme Court of Florida is now in session. All who have cause to plead, draw near, give attention, you shall be heard. God save these United States, the great state of Florida, and this honorable court. Ladies and gentlemen, the Supreme Court of Florida, please be seated.
Good morning and welcome to the Florida Supreme Court. We turn to the first case on today's docket, which is Shine versus the State of Florida.
Mr. Chief Justice, and may it please the Court. One of the guiding principles of sentencing under the Criminal Punishment Code is the broad discretion imbued in our circuit judges to hopefully reach the right outcome in each case. But in two ways, the Third District's decision here curtailed that discretion. First, the sentencing court, looking at the totality of the circumstances, concluded that the very same concerns for drug rehabilitation that animated the original downward departure were still present later and warranted a second departure. Under your decision in Frankie's, that was a valid exercise of discretion, and yet without even citing to that opinion, the Third District reversed the departure. Second,
In Frankie, didn't we say that the judge had to say something more than just the fact that that was the downward departure to begin with?
yes.
So what more can a judge say than that?
Justice Labarga, in this particular case, the judge not only pointed to the fact of the original departure, he then assessed the totality of the circumstances in writing and wrote that the new departure would address my client's demonstrated need for drug rehabilitation. He said that there would not only be a lengthy period of incarceration, but also residential inpatient treatment.
If the original offense was a drug-related issue,
Yes.
then I can see where a judge can say the violation, in your case, involved him testing positive to some cannabis product.
Yes.
I can see a judge saying, well, let's continue with that because we're talking about long-term treatment and that type of thing. But what happens if the original offense, say, was non-drug related, say it was a robbery, and now he reoffends because he tested positive for something? How is that in line with the original thought for the downward departure?
Well, I can tell you what motivated the parties to reach the original plea agreement and the original departure was concerns about my client's drug rehabilitation, and that's why they originally agreed to 6 months jail followed by 3 years of drug offender probation. So that was their agreement, and then when my client later violates by testing positive for drugs, it is within the sentencing judge's discretion to look back at that and say, I still believe that that is a consideration that's present in this case, and here's how we're going to try to fix the problem and address it going forward. And I think effectively what the judge did here was realize that the path to recovery for recovering drug addicts is not generally linear. It's a bumpy road oftentimes, too often. And so what the judge did was reassess the facts of the case, updated his discretionary calculus, and still concluded that the original concerns were present and another departure was warranted. And that's perfectly appropriate under the framework that you laid out in Banks, which says that as soon as under step one, the judge reaches the conclusion that there is a valid mitigating factor, and in Frankie's you said the fact of the prior departure, that counts under step one. It goes to step two, at which point it's essentially doing an in-range sentencing calculus where it looks at the totality of the circumstances and has to make a decision about what is presently the best sentencing outcome given this particular defendant in the particular set of facts. And that's, I think, what you have here. We not only rely on your decision in Frankie's, but we think that there is actually a textual basis for the outcome that you reached in Frankie's, and that's twofold. Number one, and I think most significantly, the text of the probation revocation statute, 948.06 subsection 2B, indicates that if a judge revokes an offender's probation, he then is authorized to impose, quote, any sentence which he might originally have imposed. Any sentence he might have originally imposed. So because at the time of the original departure, a departure was an available sentence, at the time of revocation, that was still available to him. He just had to exercise his discretion. And under Frankie's...
But the problem with that, it seems like if there's been a change in the circumstances, I'm having a little trouble understanding how something the state agreed to begin with is still something that is would fall within the scope of that when the state no longer agrees to it. Because it's all predicated on the state's agreement, right?
Yes. I think that's right.
That's like that's there in amber, always and forever and still available, no matter what happens subsequently.
Well, if you look at the text of 921-0026-2A, which is the mitigating factor for uncoerced plea bargains, it doesn't say that that's a mitigating factor up until the point when the defendant violates and you revoke probation. It says the fact of the plea is a valid mitigating factor. And we are not saying that my client was automatic, and this is Frankie's, we're not saying my client was automatically entitled to a downward departure. What we are saying is that under step one of the bank's framework, the fact of the prior departure opened the door, and then everything else was the judge's discretion. And
let me ask you this. In this case, how do we know what part of the judge's comments with respect to the sentencing fall within step one and what falls within step two?
I don't think it's always clear, but in this case, based on the structure and the text of this downward departure order, the judge identifies what he calls a non-statutory mitigator and specifically points to the fact of the prior departure, and then in the rest of the paragraph appears to do what is a more traditional in-range sentencing calculus, where he goes through and he tells you exactly why he believes the prior departure still warrants the new departure. So I think that you have that in this case, and that's exactly what Frankie's tells the judge to do. He didn't just look at the prior departure and automatically grant a new one. He updated the calculus and treated the case anew to have a real look at the totality of the circumstances. I think that's exactly what we want our sentencing judges to do, to look at the defendant in the position that he's currently in when making that decision.
Let me ask you this. If the judge had said, okay, you proved the violation, but I elect to just continue probation, I'm not going to revoke, the probation would have continued. There would be no requirement, no matter what the law was, to do anything else then, right?
Yes.
So it would sort of be odd when probation is a matter of grace of the court to say that the judge can continue the prior sentence or can do 6+ years in prison, but doesn't have the flexibility to deal with the defendant consistent with the sort of theories of probation. Would you agree with that?
I agree, Justice Lawson. It would be anomalous to say that he could continue the probation but couldn't revoke and then not do a downward departure. I think that would be a very odd outcome. Going back to the question about the state's agreement and the significance of the state's agreement in this case, I think there were really two bargains in this case that were struck by my client. The first was the original downward departure. My client's consideration, what he offered to the state, was a guilty plea. And he kept that part of the bargain. He pled guilty. The state's consideration was to waive the bottom of the guidelines and to recommend a departure sentence, and they did that. That's that bargain. He hasn't violated that in any way. What he did was he violated the second bargain, which was between himself and the court. When the court put him on probation, it was telling him, you're going to not get a prison sentence, and in exchange, you must abide by the terms of probation. He didn't do that. But that means it was up to the judge at revocation to decide what his fate would be, and that's exactly what this judge did. If there are no other questions about...
I do have one question. As a matter of just statutory construction, it seems Frankie's seemed sort of odd to me, because it seems like if the statute says that this is a valid basis for departure, but it doesn't, you could read it to mean if there's original departure based on a plea that that's a basis for departure on probation. You could read it as saying no. It just isn't particularly clear on the issue that we're talking about. But it would seem that if the statute meant that the basis, that an original plea to a downward departure justified a departure on a violation of probation, that would always be the case. Just as a matter of statutory construction, either it is or it isn't. You want to address that if you can?
I'll tell you the way that I've understood Frankie's, and that's in light of the subsequent Banks framework. I think what Frankie's was saying, or maybe the best way to read it, is that it is a valid step one factor, the fact of the prior departure and agreement. However, the judge still has to do the discretionary calculus under step two. I think that's a valid way to read Frankie's. So that the plea counts under step one, and then the judge has to...
But with every other factor listed in the statute, it's unfettered discretion. In other words, if you find the factor, then it's just what the judge decides. I mean, and there's no saying, well, that's not a good enough reason to exercise your discretion. So this one would be different in that regard, right?
Well, I think that if you were to decide Frankie's today, you might look at it as, you might reach a broader result, which is that the fact of the prior departure authorizes discretion, and we don't look and question what the discretion was, and there doesn't have to be an explanation to tie it back to the original departure. I think that would be a valid outcome, but we take Frankie's as we find it, and the language of Frankie's is that effectively you satisfy step one, and then you have to turn and explain your discretionary calculus, and that's what the judge did.
It seems like the downward departure pleas fall into one of two categories, in my experience. One would be, based on the circumstances of this case and this defendant and everything, this just doesn't justify the sentence that the guidelines call for. The other is, we have a real problem with this case, and so we're willing to give a plea that we wouldn't otherwise because these facts don't justify that. I mean, and a lot of times that's reflected on the record when the judge is saying, why should I accept this plea, right? So it does seem to me that in those instances where the state may have a witness problem or something and there's that kind of record, it might be very hard for the trial judge to justify at a violation of probation reasons why the probation should be continued. But it also seems like in the other kind of case, maybe that it would be almost always easy for the judge to say, well, these conditions are still in play. Does that make sense?
That sounds fair to me. I would point out that this is the circumstance in which it wasn't that the state had a witness problem.
Right, yeah.
We know the reason for the first plea, and that's because of the need for drug rehabilitation. Mm-hmm. But I think one way or the other, there is clearly, in our view, a statutory basis for Frankie's, whether you want to look at it as the statutory mitigator for plea bargains or the probation revocation statute. This judge had as an available sentence any sentence which he might have originally imposed. He did that, and then he furthermore explained why he thought the original departure was relevant. So that's how we see the merit.
I wanted to ask you about remedy. What remedy should be imposed? Assuming we agree with you, what is the remedy for the trial court?
The remedy here is controlled by Jackson and Glover, and that is a remand for de novo resentencing.
And that's what the Third DCA did incorrectly, according to your argument.
Correct. The original panel decision was a remedy that we agreed with for de novo resentencing, and then on rehearing, the panel changed its mind. Now this sentencing judge has its hands tied at resentencing, even if it believes that there is a valid mitigator, and even if it believes that a downward departure is the most appropriate sentence for this case, it will have no power to do so. And
the sentence will have to be 70 months, whatever the guidelines call for.
Exactly. And that's...
But you don't really think we need to reach that issue?
That's correct.
Because of the other issue we've just been talking about?
Yes. Yes. However, if you were to disagree with our reading of Frankie's and the statutory scheme, you would address the remedy question. I would start by noting that unlike what the state has argued in this case, Jackson really is on all fours. Jackson is, upon further reflection, not just a case in which there was a reversal of the departure for procedural reasons. It's true there were no written reasons there. However, the First District in Jackson also reversed because the oral reason provided by the sentencing judge was found to be substantively invalid. So in that respect, it is no different from this case. And what Jackson did was look at the statutory scheme, to determine whether the CPC precluded on remand the sentencing judge from doing exactly what we typically expect sentencing judges to do, look at the case de novo, all the totality of the circumstances, and reach what you believe to be is the correct result. If the court has any questions about the remedy.
Sorry.
Yes.
So when you, on your point about the two bargains, doesn't that undercut, though, the idea of then relying on the bargain that you said has basically been kind of negated as the gateway kind of step one for the departure?
I don't think so. In my view of the two bargains, it's the bargain with the state that waives throughout the entirety of the case the bottom of the guidelines. And the state is saying, we believe this is a case in a defendant for which a downward departure is a valid sentencing outcome. So that's how the judge gets to the original departure. The second bargain is you must abide by probation. And we know that probation is a matter of judicial grace, and if you violate probation, the offense is not against the prosecution, but against the court itself. And because it's an offense against the court, it is the court's responsibility to decide how to punish the violation. And that's why the judge, at the end of the day, like under Frankie's, has the right to say, I'm exercising my discretion, and I don't think that a lengthier bottom of the guidelines prison term is required. That's how we view it. I hope that's...
So you're saying, but doesn't the Frankie's case suggest that there could be, when it says that it can sometimes be okay, I took that to mean it can sometimes be okay kind of at step one, but it sounds like you're saying that when it's not okay, it's more because of the step two reasons.
So I
you know
should
what I
know.
mean? I mean, this is
No,
all
I
like
understand.
this made-up construct, but you know what I'm
Yes.
saying?
I think the confusion in Frankie's is most likely because it predates your decision in Banks. It didn't have the benefit of the boxes, the step one and step two. The way that we have understood Frankie's, though, it's essentially a precursor to that two-step framework, where the reason that it is sometimes appropriate to depart, which is really just saying it's a valid factor, is that under step two, the judge is not required to automatically depart. He has the discretion to decide, is that still the proper outcome for this particular defendant under these facts?
And in this case, the judge gave several reasons, and do you agree that some of them were not valid, the ones about the sentence being too harsh and that sort of thing? I mean, really, if absent the sort of drug rehabilitation
Right.
part, do you agree that the other stuff would be error?
I think that if they were the standalone mitigating factors cited by the judge under step one, that they would be problematic. And we wouldn't be here raising that claim. However, as soon as the judge identifies the valid mitigator, which was the prior departure, it then has to do a much broader calculus under step two. And at that point, effectively, as soon as step one is satisfied, in our view, the bottom of the guidelines becomes 0 months. And what the judge is doing is exercising in-range discretion from 0 months up to the statutory max. And we know that in-range discretion, it's perfectly appropriate for a judge to consider things like the harshness of the sentence or a need for drug rehab. So that's our view. Step one is satisfied, the bottom of the guidelines no longer exists, and you do in-range discretion, and really everything is on the table except for those few either statutorily or constitutionally impermissible factors like race or remorse. Those things you couldn't do, but everything else is just in-range discretion. For those reasons, we're asking that you reverse on either of the issues. Thank you so much.
Thank you.
May it please the court, Jonathan Tanous on behalf of the state. Justice Lawson, I agree that Frankie's is a bit unclear in the way that it explains how the downward departure works here. But what I believe is that in Frankie's, it's saying that it sometimes can be a factor, it can't always be a factor, and the trial court really needs to explain what facts or evidence it's relying on to explain why it is a factor. And I think that really makes sense to the extent that when a defendant...
But the trial court did that here.
Well, I think the facts or evidence that the trial court did rely on...
So you agree with Frankie's. You're not asking us to recede from that or anything like that.
No, I'm not asking you to...
So if there was a plea to a downward departure here, and so under Frankie's, that justifies a downward departure as long as there's a reasonable explanation as to why the judge thinks that should be true. And are you saying that the explanation here was not reasonable?
Well, what I'm saying is, in the normal course with the downward departure, all the judge has to do is list the factor or ground that they're relying on to justify the departure. But what sets Frankie's apart is that it says it's not always, it's not never. And so what it's saying that the trial judge is supposed to do is to explain in writing what facts or circumstances surrounding the performance of the defendant under the agreement would justify the prior breached agreement for a new mitigated sentence. And so...
I asked my question, Mr. Sousa, to give you time to think about it really, because to me, Frankie's does make sense when you consider that there are pleas to downward departure where the problem is the state's proof. And that may be reflected on the record. And it would seem like if in a case like that, that would be a rare instance where an appellate court could say, well, that just is an abuse of discretion. If all you do is say there was a plea originally and the record reflects that the guideline sentence was fully justified but there was a proof problem, then, and I can't think of another downward departure in another situation where that might be true. So in light of that sort of weird fact about the two ways you get to a downward departure plea, doesn't Frankie's make sense?
So I think, here the problem is as well is that this is actually a new ground. We're not relying on the old ground. And there's specifically in the statute that says that drug addiction or substance abuse is not a mitigating factor under any circumstance except for drug offender probation. And I understand that drug offender probation was part of that initial agreement, but that was an agreement between the defendant and the state because the trial court was not allowed to offer probation without the state's consent. The drug offender probation must have 60 sentencing points or less, and here the defendant was well over those 60 points. And so...
I mean, the nature of probation is that it's within the trial court's grace. I mean, that is just so clear in our law. And if the state originally says, okay, this is a deal we're willing to take, and the defendant agrees, we're willing to put this defendant in this case in the judge's hands in order to do what judges do when they're supervising, when they're handling a probation case, wouldn't it be odd to let the state come back and say, no, we don't like the way the judge is dealing with this probation matter, and so we're gonna undo the bargain and say we're gonna take this back into our own hands? Wouldn't that? I mean, doesn't the state sort of give the right to object away at the time of the plea bargain when they say, okay, probation's going to be good?
Well, I think we have to look at a discussion in Nickerson, which discusses this court's case in a Segarra, where it basically says that once a defendant breaches or violates probation or breaches the agreement, the state is no longer bound to that agreement. And so, I think what Nickerson was trying to do is look at that rule and then look at the statutory ground which allows for downward departures based on uncoerced pleas.
So, in this case, am I correct that the trial judge could have found a probation violation but could have just said, I'm not going to mess with the sentence, I'm going to continue probation?
That is
and we wouldn't be here.
That is always an option, and they
Right.
can always impose a term of jail time as well. It's just that this is a very unusual circumstance where at the time of Frankie's, actually, substance abuse treatment actually was a statutory ground that the trial court could rely on. So I guess at that time, if the defendant had brought this argument, I think you have a pretty good argument. But since the legislature has told us that we just can't rely on substance abuse or addiction.
When was that change made? Because I thought it was before this.
I think it was made after the code. I think Frankie's is a 87, 88 decision.
After Frankie's, but okay, yeah.
Right, and so...
Let me ask you this. I mean, in this case, he was placed on drug offender probation. Am I correct?
Correct.
So he would qualify for that exception of the statute, had the judge mentioned it in his order. And I am reinstating him on probation, on sentencing him only to 40 months or whatever it is, because he's on drug probation.
Correct. And the problem is that given this is a brand-new downward departure, we have to look at 921-0026, and it specifically tells the judge that they cannot rely on substance abuse treatment or addiction, and the defendant didn't have the benefit of an agreement with the state at the revocation sentencing.
But he was sentenced, I hate to use the word sentence when you put somebody on probation, but he was placed on probation, drug offender probation for 3 years. So he was on drug offender probation. Correct? Am I right?
Correct. And
So had the judge just said in the revocation order or whatever, the sentencing order said, I am reinstating him or sentencing to 40 months as an exception under the drug offender probation, then that would have been fine.
Well, I think with reinstatement, they're strictly limited to jail time. So I think the 40-month sentence may have not been available. But again, the defendant breaches the agreement based on possessing drugs and resisting arrest. And, one of the integral provisions of the agreement is, that the defendant won't use drugs and will follow the law. And so I think this court's decision in Segarra really kicks in, and the state isn't bound by the agreement. The trial court isn't without the benefit of a state agreement to depart downward, and so it has to find other grounds to justify this new departure. And the defendant mentioned that if a defendant revokes, that we should consider that this is simply modifying what was initially agreed. That was actually discussed in a Fifth DCA case that's discussed in Frankie's, and Frankie's outright rejected that argument. And so I think it's sort of a catch-22 situation, but under these circumstances and given Frankie's, there just wasn't enough in the order. The order really should look at the nature of the agreement, the terms of the agreement, and the defendant's performance under that agreement to explain the facts that would support that ground for the downward departure. As to the remedy here is a guideline sentence. That's the remedy in Florida for the past 30 years. The DCA's uniformly applied that remedy before the CPC. I think we can presume that the legislature was aware of that remedy when it enacted the CPC. And, really we've only seen a change in that rule since this court's case in Jackson. And, we think that Jackson is distinguishable in that there was no written order. None of the conflict cases in Jackson had a written order.
The court in Jackson did not deal with the issue as if that was the only issue. They specifically said there is no written order and the oral reasons given do not support a downward departure. So they looked at substantively there was no basis given that was justified under the statute, correct?
I agree with you.
And they also framed the issue, I'm quoting, as whether an appellate court that reverses the imposition of a downward departure sentence must remand for resentencing within the CPC, or whether it may remand for resentencing outside the CPC. I mean, that's what the court said, right?
Yeah, but the court did rely on the CPC statutory requirement of the written order, and I think the court was trying to anchor their rule and somehow in the CPC.
Well, but it also requires a valid reason. I mean, this distinction based on the written order versus the reason, I don't understand how it's any different under the statute. The statute requires both written reasons and valid reasons, correct?
Correct. And if the court doesn't think that it's a meaningful distinction, we would ask the court to recede, from Jackson. There's really no conceivable strategic reason for...
Well, how would then that, if we did that, how would that fit within the law that's out there that resentencing proceedings are de novo.
So I think the case law that's been cited that resentencing are de novo are generally Higgs violations. In those situations, it's essentially a score sheet error, which is consistent with the rule in Shull in that the trial court must comply with the code. So to the extent that the trial court doesn't comply with the code or relies on an invalid score sheet, the state would agree that under Shull it would go back for de novo resentencing. But here the trial court complied with the code. The defendant was given a full and fair shot to present grounds in support of the departure. And so under those circumstances, given...
Well, but your position isn't really even about necessarily about what how the defendant has presented things. It's about what the trial court does. And it just seems to me a very odd rule to say that the defendant is going to be jammed by a misstep of the trial court. Now, whether the defendant waives something, that's a different issue. I think our rules about de novo sentencing have an answer for that as well. But your position here seems to me to be very, kind of go as far, it's kind of an exaltation of this formalistic thing. If somehow the trial court misses the boat, got one shot, that's it. I'm struggling to see how that makes sense.
And so I think, the defendant, it's an unusual circumstance in a criminal case where the defendant actually has the burden to present reasons and present evidence. Sure, the trial court is free to impose a downward departure without that, but given that, I think...
But your position is regardless of what the defendant presents and what the defendant does, if the trial court missteps, that's it.
And I think it's different...
Am I correct in understanding that that's the state's position?
Well, I think it's different between a misstep where...
Errors. However you wish to.
Trial court, fails to use a correct score sheet, fails to enter a written order.
For example, say that the defendant presents two bases for downward departure, evidence on two, and the evidence would support a finding on two, but the trial court just makes the finding on one, and the defendant says, well, what about my other grounds? Well, I don't need to address that. And then on appeal, they find that that was not a valid reason, but the other one would have been. The trial judge didn't address it. So it's a preserved issue. It's an issue where if it was remanded, even on that evidence, the trial court could have come up with a valid basis. But even in that circumstance, you're saying that it's a remand for a guideline sentence, right?
Yeah, and I know that's the rule in Shull that we look, are there any valid reasons in its order? So,
and you think that would be a fair and just outcome?
Well, I would say that, the defense is on notice of this longstanding rule as long as they're able to present those reasons. As well, this has been incorporated into the CPC as part of a largely statutory scheme maybe to the extent that there needs...
I'm just not following you. How has this been incorporated into the CPC?
Well, 3704B says that any prior precedent implementing the guidelines to the extent not inconsistent with the rule or the guidelines continues to be good law. So in my mind, we had a uniform, district courts uniformly applied the rule. We don't have a decision from this court because it was uniformly applied. And so to the extent that the legislature was aware of the rule, perhaps a new rule needs to come from the legislature. But ultimately, where there were invalid reasons in the written order, and the rule of law for the past 30 years has been remand for resentencing within the guidelines, we'd ask that you affirm the Third District's opinion. Thank you.
I want to make sure that I've addressed all of your questions. But in closing, what I would say is the overarching principle that we think controls this case is that our sentencing judges have the awesome responsibility and the ultimate responsibility of arriving at what is the just and most appropriate sentence for every given offender under those set of facts. And where the parties have specifically put into issue drug offender probation.
But of course, subject to the restrictions that the legislature has placed
Yes.
on the sentencing process.
Of course, but when you have a case where via the prior agreement, the parties have put into issue this consideration about drug reform and drug rehabilitation, we believe that that is a valid consideration for the trial judge to take into account under Step 2 based on the prior agreement, and we have that, and under Frankie's, the departure was valid. Thank you for your time.
Thank you.
Thank you both for your arguments.